Good morning, everybody. I think we will now begin, just with a slight 5-minute delay as we let people join this morning. Thank you all for joining this webinar, which is to mark the International Day to End Corporal Punishment Against Children. As many of you will know, corporal punishment is one of the most common forms of violence against children in the world. It is any form of punishment in which physical force is used to cause some degree of pain or discomfort, and this is however light. And it's also physical punishment, non-physical punishment that could be considered cruel or degrading. There's a lot of different data from around the world which shows us that around 80% of children will experience some form of corporal punishment within their childhood. And it's still legal in many countries, including Sri Lanka. Today, there are 62 nations that have fully prohibited in law corporal punishment at home and in school and in institutions. The first country to do this in 1979 was Sweden, and still in my own country, in the UK, it is not completely prohibited at home. It is still somehow legal to hit your child. So I don't want to only talk about the statistics in my opening remarks, but also perhaps that although prohibition in law may be a first step, there's also a huge amount to do on social norms and beliefs and practices. So I wanted to talk a little bit about my own family to show how even across generations, it takes time to change these practices. My mother was born in the north of England to a vicar, and he himself had been severely disciplined by his father, thinking that this was the right way to educate children. And so my grandfather then brought this into the way that he disciplined his children. And I think I can say that it was, fear that reigned in the household. My mother and her brothers were beaten, and they also were victims of this non-physical forms of punishment. For example, my mother had told me a story about how she opened her Christmas present on Christmas Day, and it was coal wrapped up, which is because she'd been naughty. So instead of getting a present, she got coal. So these types of punishment have lifelong impacts on children, and then impact on the way that these adults then parent themselves. So I know that my mother struggled a lot to change her way of parenting, and with the support of my father, they tried to bring in a different way. Not easy. Definitely, I was smacked when I was naughty. I know a lot of people say I was hit and I'm okay. So maybe people are okay, but who would know how they would turn out or how relationships might be different if they hadn't been hit as children. So when I became a mother, I was not yet working for UNICEF, but I had this, family background of the norms changing through the generations. And it's still, as I said, it's still not prohibited in law, corporal punishment fully in the United Kingdom. But I had all of the evidence and research at my fingertips. I could read about brain development, and I knew that when children are very small, if they experience violence in the first few years of life, that creates different neuron connectivities in their brain and changes the way that their brain develops. I also had at my fingertips in many different forms of positive discipline techniques, including timeouts and rule setting and behavior charts, which I've then used with my children. Parenting is not easy. Bringing up children, especially now in a time of COVID, is not easy. There is extra stress on parents. So I really wanted to share that as a way of showing that over time and over generations, these things can change. It's not something that changes overnight, and even prohibition in the law doesn't mean that the social norms change. It's a journey, but it all starts with a step and with open discussion about these issues, about discipline at home, about discipline at school, and about discipline in institutions such as daycare and orphanages. So with that opening remarks, I will also now just quickly go through the agenda for this morning. I'm Miranda Armstrong. Sorry, I should have perhaps introduced myself. I'm the Chief of Child Protection for UNICEF in Sri Lanka. I will then hand over to Pritika from the Ncpa, from the National Child Protection Authority, who will give perspectives on ending corporal punishment from the government. I will then hand over to my colleagues Hemamal and Rahana, who will talk more specifically about corporal punishment in schools and the recent landmark verdict in the Supreme Court in Sri Lanka. Then we'll hear from Dr. Tush, who is the chairperson for Stop Child Cruelty and who's been leading a campaign in Sri Lanka for many years to focusing on ending corporal punishment with a focus on schools. And then we will have a question and answer session, which will be moderated by Himaja, who works at UNICEF. And then we'll see if there's time for some closing remarks at the end. So thank you for joining us and looking forward to an interesting discussion and listening to all the different viewpoints and perspectives that are out there. Thank you very much. Over to you, Madam Pritika from the Ncpa.
Ms. Pritika, if you could unmute yourself, please.
Today we are gathered here for the International Day to End Corporal Punishment of Children. I'm happy to speak about the perspective of the government of Sri Lanka on this. My talk, or the points that I will be discussing here, will be based on firstly on laws and policies of the government of Sri Lanka on ending corporal punishment of children. This will be the preventive and response mechanisms to address this issue. By preventing and response mechanisms, the government of Sri Lanka is trying to ensure the protection of children of this country. As the first step, I would like to say Sri Lanka became a party to the United Nations Child Rights Convention by ratifying it in 1991 and thereby committing or placing its commitment towards the global population to address the physical violence as a method of discipline in all settings. But would like to say, prior to ratifying the CRC, government of Sri Lanka signed and acceded to International Covenant on Civil and Political Rights. That was in 1980. And thereby committed to provide rights mentioned in the International Covenant on Civil and Political Rights to all living in Sri Lanka, to men, women, and children, all people living in Sri Lanka. Not only the ICCPR Act, but optional protocol to the ICCPR, first optional protocol to the International Covenant on Civil and Political Rights, provide facilities for the victims who have felt that the government has not done enough, or the remedies within the law is, and where they could make their grievances, where they could report their grievances or their communications to the UN. This is the government perspective. This is the government commitment towards ending corporal punishment in Sri Lanka. This is where we have started. GOSL has acceded in 1997 to this OP1, to the ICCPR. And in 1995, the legislature or the Parliament of Sri Lanka identified certain forms of physical punishment, and it was made criminal by including a new section to the penal code, 308A. That penal code was amended and a new section was introduced as cruelty to children and criminalized certain forms of physical violence, physical abuse, and showed its commitment to protect children. This 308A section was included into the child abuse definition of the National Child Protection Authority Act, which was enacted by the same parliament in 1998. And it was included in the child abuse definition, which Sri Lanka Parliament introduced in 1998 through the Criminal Procedure Code Amendment Act. National Child Protection Authority was established under an Act of Parliament, which was enacted in 1998, Act number 50 of 1998, which the Parliament had the intention to formulate the national policy on protecting children, formulating a policy to prevent, protect, and rehabilitate and reintegrate of children who have become victims of abuse. The definition of child abuse, as I have mentioned earlier, the definition of child abuse includes 308A, which criminalizes forms of physical violence or physical abuse against children. This is the government perspective. The government is committed on ending corporal punishment. And you would see once this new section is introduced, Attorney General started sending out indictments based on criminal investigations conducted by the law enforcement agencies. There were cases heard in high courts, this being an indictable offense, and there's judicial activism, where you can see clearly through the judgments available at the superior courts that's mentioned in the Ministry of Justice website. If anyone wish to go through, can visit the Ministry of Justice website and study these judicial activism, the superior courts, Court of Appeal, these 308 cases, 308A cases where they have come as appeal to Court of Appeal level as well as to the Supreme Court level under the fundamental rights jurisdiction on inhuman, degrading treatment and punishment that is mentioned in the Constitution of Sri Lanka. Then today, in today's context, when you talk about laws and policies, in 2019, the Cabinet of Ministers approved the national policy on child protection. Now we are about to launch the implementing stage of this policy. There are 10 ministries working together in an integrated service approach to provide best for the protection of children. There are 10 ministries working together, plus the civil society organizations in implementing this. Now we are at the final stages of developing action plans to implement the policy. Apart from these laws and policies that I can bring forward to you with regard to the government perspective on ending corporal punishment, I would like to say mention few responses that the GOSL has made with regard to ending corporal punishment on this day on this day to end corporal punishment that is being declared as a national day. National Child Protection Authority, the Board of Directors of the Ncpa, appointed by HE, the President, has approved appointing a legal subcommittee to look into the laws of corporal punishment and to identify the lacunas or the areas that needs to be addressed, and to make legal recommendations needed for legal reform on this subject. And National Child Protection Authority, and there are other agencies who has conducted research on this area on corporal punishment against children. The recent research that the Child Protection Authority conducted recommended positive disciplining methods to be promoted amongst the caregivers, teachers, and parents. So the National Child Protection Authority is working very closely with the Ministry of Education to promote or to teach or to build skills amongst the teachers on positive disciplining. So we have identified that the corporal punishment most is being inflicted by parents, teachers, and caregivers. So the positive disciplining methods have to be discussed amongst them. They have to be given knowledge on this, and they have to be promoted. They have to be given skills to use it in their everyday settings in order to protect children from corporal punishment and to end corporal punishment if we really want to do it. Then Ministry of Education appointed counseling teachers in government schools. The aim of this appointment of counseling teachers was to assist the victims as well as potential perpetrators who would inflict corporal punishment on children, especially when it couples with anger. Then Ministry of Education contributed by issuing circulars to all the educational settings of the government institutions, government educational institutions in 2005, 2011, and 2016. All these circulars discussed about the ill effects of physically punishing, physical violence to discipline children, and promoted positive discipline amongst teacher community in government school settings. National Child Protection Authority found a way to empower children by establishing school child protection committees in all schools. This was aimed to empower them on their right to protection from all forms of abuse, not only corporal punishment, not only physical abuse, but all forms of abuse, that being the mandate of Child Protection Authority, and that is what the CRC, the protection component, is for. So School Child Protection Committee is a forum that was established to strengthen the interrelations amongst teachers not only in schools, but also in family settings. In school child protection committees, a happy sad box was introduced for children to make complaints or children to voice their opinion about things happening in school, not only related to the protection component, but everything, where these issues will be addressed to ensure a safer environment in school. The National Child Protection Authority is empowered by the statute under Section 14 to entertain complaints of violence or rather of child. Introduced new mechanisms for people to make complaints. We have a helpline, we have a 1929 child line, which is in operation for 24 hours, during 24 hours of the day, 7 days of the week, in all 3 languages, and it's a toll-free line. So apart from the call center, we have introduced a mobile app, and there's a post box introduced. There are people who drop a postcard. Yes, PO Box 1929, Sri Javadanapura Kotte. The letter will come to Ncpa faster, apart from these 2 electronic mechanisms of complaining. Then the government of Sri Lanka had to sensitize investigators. Now, all this information that is gathered will be disseminated or will be given for investigation by the relevant authorities. So the government had to sensitize the investigators, knowing that children would be using these complaint mechanisms against their caregivers, their teachers, and parents. Because we have ample evidence when you analyze the reports of investigation that most of the complaints on corporal punishment was found to be false after the investigation. Now, Ncpa took a step forward without waiting for anyone to complain. Ncpa started monitoring media, print media as well as electronic media. Not only that, social media also. The incidents reported in all 3 medias, these medias I mentioned on corporal punishment, Ncpa started addressing them. So this is a very proactive. This is a very proactive step. We are going 1 step ahead without waiting for anyone to complain. The government stakeholders in implementing the national policy on child protection advocate skillful parenting under the national agenda through information, education, and communication tools. We use booklets, phone lines made available for people to seek information on skillful parenting. One is 192, that is functioning under Ministry of Health, and there's 1938 functioning under National Committee on Women that functions under the Ministry of Women and Child Affairs, where parents could seek help from MOH clinics on developing skillful parenting or the parenting skills, especially with regard to handling children's issues. And Ncpa has started coordination, referral, and response on psychosocial support for parents who face difficulties on these issues. I would like to mention that the government of Sri Lanka is working very closely with civil society organizations, INGOs and UN organizations on children, on child protection issues. We meet regularly. These days, of course, we meet virtually. And we discuss and identify the areas that need priority in child protection. This is called Interagency Child Protection Working Group. And government has taken steps to address the physical abuse, the big picture, which corporal punishment is a fragment.
Madam Pritika, just flagging you have 2 minutes left.
Yes, thank you.
Thank you very much.
Government opinion on this is an attitudinal change to end corporal punishment in all settings. The government opinion is the attitudinal change of the society and better skills on parenting, teaching, and caregiving. And we have provided services and we are committed to address this issue. We'll be listening to children, parents, caregivers, teachers, general public, and government and the partner ministries on addressing this issue. Thank you so much for being with us. Thank you. Let's work together to address this issue in Sri Lanka. Thank you.
Thank you so much, Madam Pritika from Ncpa. Now handing over to Hemamal and Rahana from UNICEF.
Thank you, Miranda, and thank you, everybody. Thank you, everybody, for participating. Actually, my role in this seminar is to brief you about the recent Supreme Court judgment, which, is very, very important and lays down, a lot of lays down kind of the foundation actually for some of the work that we as child protection partners could do. So let me briefly tell about the background of this case. The case, is the reference is SCFR 97-2017. If you type this case number in the web, you will get the full PDF of the case from the Supreme Court website. I have given in the slide the petitioners, who are actually the mother and the father and the child petitioner. So from this itself, actually, you will see the sensitivity of the Supreme Court, where the child's name is not mentioned. Like we often we often hear of situations where the child's name is mentioned, and then also where reports are made through the media related to children with the name mentioned and identification mentioned. So this is a good example here also. Then the respondents, of course, were the teacher who hit the child, who was the art teacher, was also the sectional head and the master in charge of discipline. And then the other respondent primarily was the principal of the school, Puhulwala Central College. Then other respondents who had some responsibility related to this incident, the Zonal Director of Education, Hakmana, the Secretary Minister of Education, and the Minister of Education at that time. And then also for completion's sake, they had included the current Secretary, Minister of Education, and the Minister of Education, and as a routine, the Attorney General. Then, next slide, please. So the case relates to Article 11, 17, and 126 of the Constitution. The judges are mentioned here. It's Honorable Supreme Court Justice S. Ture Raja, who's delivering the judgment with the rest of the judges concurring. Action was initiated on the 7th of March 2017, argued in 2020, decided in 2021. So here I have mentioned that also partly as for us to get an idea of the time taken for cases. Like we know that in the magistrate courts, it does not take so long for cases. In High Court, we know that substantial time is taken, although the backlog is quite a bit cleared right now. Even in the Supreme Court, we see the time it has taken from the completion to the delivery of the judgment. Now the child was 15, 2017, now must be big, an adult. Next, please. Yeah, so facts of the case, basically in 2017, during the agricultural period, the victim child with other children were asked to plow part of the school. They were doing the plant nursery to plant vegetables. While plowing, the child felt fatigued and sat on a half wall near the plant nursery for a short period, for a short break, and resumed the activity. It was for a short period. Then a classmate was also accompanied the child. While the child was washing his hands and tools, two other students came and told that the art teacher has asked him to come to his office. Then the art teacher has asked, why you're sitting there. Hasn't the principal previously warned not to sit on such a dangerous place? And questions why they were sitting. So I mean, the words used are also derogatory, in the sense in Sinhala it says koheda yako umba ara wadi vela hitiye. Koheda yako means kind of devil. Where the devil have been sitting is kind of this thing. Whereas of course in the judgment it's kind of decently referred to as where was it that you were sitting. Next slide please. Then the teacher slapped the child across the face, and the blow landed on the child's left ear. The teacher had then chased the child out. He had then been in his class and remained in excruciating pain. So the art teacher was informed of the situation. He came to this class where the child was and told, don't take note, over Ncpa, kind of brushed it aside. The class teacher was informed that the art teacher had hit him, that his ear was hurting, and that he wants to go home. The child wanted to go home. So now this is also significant. The listening to the child wants to go home. We often don't believe the child. The child really needed to go home. The pain was such. But then the class teacher responded saying, no, don't worry. It may go away. Okay, ගෙදර ගිහින් එක දෙක කරලා අම්මට කියන්න එපා. Like don't double the thing and tell your mother. So that was the response from the class teacher. Class teacher is not a respondent, of course, in this particular case. Yeah. Then the art teacher later came with another teacher who spoke to the child and said, if the ear bleeds, come and tell. And then also offered tea. To take the child to the canteen for a tea. Then the child was not given any medicine. Child was not shown to a doctor, or there was no offer of such thing. The child himself went to the school canteen and got 2 paracetamols. Then no staff member offered any form of medical assistance. The judgment notes that fact. Then child was not allowed to go home. No staff member informed the school principal. So those are significant here and lessons for the future. Then principals was only informed by a family member prior to hospital admission. Then the child returned home at the end of the school day and told the incident to the grandmother that the ear was aching. Now we note that the only chance that the child got to tell someone else, like in the family, was after he went to school. But we will see later in the case that the teacher is trying to make it in favor of him in his defense, that child didn't promptly tell. But the judge understands that there was no opportunity for the child to promptly tell. Then the child is taken to the Kirinda the Puhulwala Rural Hospital, which is the smaller hospital. Then his ear examined. Doctors, upon diagnosing eardrum damage, referred the child to the more advanced hospital, which is the Mathura General Hospital. The referral note says, this 15-year-old schoolboy complains of loss of hearing in left ear following an assault to the ear by a teacher. Penetration of the eardrum. Please admit for ear, nose, throat opinion. And child was also later transferred to the teaching hospital, Karapitiya. So this is something actually encouraging, that the doctor actually noted the facts as told to the person. So sometimes we see, like, doctors saying complaints of assault or something like that without being specific and kind of insulating the perpetrator, especially when it's a family member or a teacher. Next slide, please. Then child was taken to the Mathura General Hospital by the mother and admitted. Now here it's noted that the child was taken to the hospital, not that the hospital actually transferred the child to the by an ambulance. But it may be innocent in the sense, like, sometimes it is common for parents to take children to the more advanced hospital on their own because waiting for an ambulance can cause delays. Then the principal and 2 other teachers were already at the hospital awaiting the arrival when the child came to Mathura. This also suggests that they were worried. They won't know what was happening. Before the child itself, they were there in the Mathura hospital. Then the statement was recorded by the police while the child was in the Mathura hospital. Child was taken by parents, and then following that, the child was discharged. Child was taken to the National Hospital, Colombo, because the parents thought that the child is still having the pain and there was not much treatment given. Then, so that's a kind of story related to the child. Then the Zonal Director of Education, Hakmana, held a preliminary inquiry as required the Minister of Education Circular 12-16. So that's a good thing that they had the inquiry. So they have acted according to the circular. Then the Zonal D's preliminary inquiry concluded that the art teacher hit the child. However, hit the child without malicious intent or with intent to cause injury. Then that it violates the MOE circular, and in response, removed the teacher from the disciplinary board and advised the teacher not to report this, not to repeat the offense. So this is, I mean, there's some good thing here that the inquiry was held, but then of course the punishment given to the teacher is questionable. It's just that, like, don't do it again kind of thing. Then another thing that you see there is that without malicious intent. Now this is relevant to my arguments later, that we need to have a specific law related to specific law, in the sense either, like, a line in the penal code or in any other law related to corporal punishment, because this malicious intent, because for most of the other penal code offenses, without the malicious intent, you can't, the police will not entertain the complaints. So then going on, teacher admits to hitting the upper portion of the body of the child. These are findings in the initial inquiry by the zonal director. Teacher admits to hitting the upper portion of the body of the child. He says that the child ducked at the exact time leading to the slap hitting the child's face, and that he is confident that the slap did not land on the child's ear. So here I see it like, it's once again blaming the victim. You ducked, therefore it's your fault kind of approach the teacher is taking. Whether this is factual or not, I cannot tell, or we cannot tell from the judgment, because I mean, as a forensic practitioner, of course, we know that when somebody tries to hit you, you take defensive movements, and this what is given here by the teacher is, of course, a standard defensive movement. Then, but we don't know whether it is true or not. Then he had spoken to the child and deemed that the injury was not serious to refer the matter to the school principal. This also suggests that the teacher has hit the child. Like, in later in the arguments, like, the court will have to actually ascertain whether the teacher actually hit. So all these things are suggesting that the teacher hit the child. Then in an affidavit that the teacher gives to the court, he contradicts this. He may have forgotten what he told in the initial inquiry. So that is in the affidavit to the Supreme Court, the teacher conducts his arguments when he projects that the child did something very risky, which was sitting on the broken wall. And it suggests that he quite calmly explained that there were other places where the child could sit, and if he felt tired, if he felt tired, he could sit elsewhere, and that only a disorderly or rowdy person would behave in such a manner. So that is what is tells in the affidavit, which is very different to what it tells in the initial inquiry. He paints a picture that after having warned the child, he simply tapped the child on the shoulder and demanded that that he does not do it again. So here, so the judge takes notes of these discrepancies in deciding what may have actually happened. Then, teacher also tried to take advantage of this delay, where he says, like, you didn't inform the principal, you told the mother only 7 hours later, grandmother, so things like that. Then some important points note here are also shown in this slide, which I've already mentioned. In the interest of time, shall we go to the next slide? Then now the questions before the court, actually, there was a violation. Was there a violation of Article 11 of the Constitution? That is like torture, cruel, inhuman, degrading treatment or punishment. Now, if you look at Supreme Court judgments in the initial time, when the Supreme Court law, actually, when it came with the 1978 Constitution, the courts actually looked at torture, like, in a very serious way, where it's really not that it's not serious now, where, like, the police hit somebody, like tie somebody on over a rope and hits and things like that. Those were what was considered torture. The court has, like, expanded the definition of this torture to include other forms of cruel and degrading, inhuman behavior. So here it's a very good example that corporal punishment in this case, the way it has been, like, the way the child has been put, is actually constituting torture. So then also, if so, is the violation covered under Article 17 of the Constitution? That is, every person shall be entitled to apply to Supreme Court as provided by Article 20 in respect of infringement or imminent infringement of executive action. So is this executive action? That's the other question. Is hitting a child by the teacher an executive act by a government representative? That kind of question is what the court is looking at. Then in making the argument, it makes a lot of reference to the UN Convention on the Rights of the Child. So this is very, very, I mean, we should be very proud of, like, having such judges. We are very, very learned, referring to a lot of things, the UN Convention on the Rights of Life. Then also the committee's General Comment 8, basically on corporal punishment. It's really looking at it and then being guided by it. There's extensive quotation from that particular comment. Then also it looks at 308A of the Penal Code Amendment, cruelty to children, and then of course Article 11, 17, 26 to see whether the case has status to be decided. Then also the judgment makes a lot of reference to the Minister of Education Circular 1216. By the way, judge also comments that this circular is like, when they had the inquiry, they are referring to this circular as 1416. So which is kind of, in my view, it was like, an expression like, they have done that inquiry in a clumsy manner without even getting the number of the circular right. So I felt that was the reason why the Honorable Justice had commented on that. Then in the circular, like, the loco parentis principle, where, like, the duty of care when a child is in school, it is the school authorities have to exert the parents' responsibility, look after the child, care for the child, not be negligent, not inflict anything that is damaging to a child. So that is there's reference made to that. Then harmful consequences of corporal punishment, that goes into detail. I'll further elaborate on that. Then board of discipline, the establishment of boards of discipline through this particular circular, which is an improvement of the previous circular. There's a reference to that. Then it refers to alternate methods of disciplining without using violence. And then also that the fact that the circular itself specifically states that violation of this circular, which is hitting children, can lead to fundamental rights violations and also cruel to children criminal offenses under 3.308 are specifically mentioned in this circular. Then consequence of corporal punishment are also stated, which is physical injury, as we all know, and in this case also is the physical injury. Then the mental impact of corporal punishment on children. In fact, this is also very much gone into detail in the judgment, where the Honorable Justice also refers to previous judgments related to corporal punishment, where it stated that justice through at least the Supreme Court kind of brings some mental redress to the injustice the child face, kind of things are there. Then emotional trauma. Then the fact that this is a lot of scientific information, which some Miranda already mentioned, that the effect on the performance of school, the cycling of violence leading to antisocial behavior as adults, all those are discussed in this specific circular. The circular is also content-wise is very, very good. Yeah, next. Yeah. Then some other things actually, which it was too much to put in slides. The things that the Honorable Justice has discussed. The judgment is critical. The judgment is critical of the record keeping and submission of this, the judgment is critical of the record keeping and submission of same to support court by the rural hospital, Karapita Teaching Hospital, and the Matara Hospital, but is not critical of the National Hospital, Colombo. So often we see that we'll be in the discussion slide for some time. Often we see doctors actually not issuing reports now for fear of having to give evidence in court. Now, which these are kind of not a really, these are ill. It's not really a real fear. Often, the hospitals sometimes fail to give reports to patients, especially when they are in the hospital for a short period of time, as they think that whoever who signed the report may be asked to come to court, but the court respects the time of the doctors, and it does not really happen like that. And so here, for example, related to the smaller hospitals, there was not much information that was provided to the patient. It's a separate discourse, the right of children actually, or children or adults for that matter, to get information from hospitals. For example, in the UK, there are special laws related to the right of patient, like the UK General Data Protection Act 2018, which gives provision related to procedures, what the hospital needs to keep, what can be given to the patient. Copies have to be given to the patient. Although the original belongs to the hospital, etc. So that's also something that I thought I should tell, especially as I understand that some lawyers who can influence policy are listening. We in Sri Lanka perhaps need such an act like the Data Protection Act, which protects data like the confidentiality, etc. of the patients, as well as gives provisions related to rights of patients related to obtaining records or getting information as to what happened within the hospital. Then the judgment is critical of the school authorities for not taking any interest in this matter. Now, the words used are not taking any interest. So, I mean, they have just done what they needed to do. Even the inquiry, it may be, like, you know, it's my opinion. It may be that, like, you know, it was held because they knew that there's a police complaint made and is going to go further. Then the judgment is critical of the zonal director for the punishment given to the teacher following the preliminary inquiry. After all, it was just don't do it again and removing from a particular position. Now, yeah. Then also, like, you know, the Attorney General nowadays does not appear for respondents when there are, like, you know, violations of human rights, which are, like, you know, of a individual nature, where it's not really justified to appear for the respondents. And then in this case too, the Attorney General does not, although the offense is committed by state officials, the Attorney General is not representing them. Usually the Attorney General represents the people, the state. Then Zonal Director of Education, Hakmana. Yeah, sorry. Yeah, then related to the questions that the judges had to make, like, you know, whether this was this a, like, you know, there was a violation under Article 11 and then 17, because those are necessary to inflict the power under Article 126 by the courts. In coming to those conclusions, there's a very good discussion by the honorable justices on the on corporal punishment itself. Now, it goes to the history of corporal punishment. It's a good analytic discussion. It goes to the history of the origins of child protection laws in Sri Lanka. Reference is made to early 20th century norms in industrial countries related to children that were like, you know, put during the colonized period in Sri Lanka. So basically, the judgment suggests that, like, you know, the corporal punishment hitting children is not our way of life, not the Sri Lankan way of life. It's the 19th century position in certain Western countries. And then there's also reference made to the ancient kings and how they have had certain laws, like, not to hit children or adults during certain periods of time. Then it refers to the CRC. Now it in fact actually looks at the evolution of the CRC also. It looks at the norms where children were looked as small adults used for very risky jobs, for example, in the Western countries, and then gradually, like, you know, accepting that with the knowledge that is coming related to child psychology, child development, etc., the gradual recognition of children's rights. So it refers to the evolution of children's rights, the recognition, the scientific knowledge that has led to the recognition of children's rights, and then also to Sri Lanka being a signatory to the conventions, and then being ratified the convention. Then also that we have our own policy, in the sense like the Children's Charter. The government coming up with the Children's Charter in 1992. So there is this very, very logical kind of flow how to justify Sri Lanka's recognition of certain international norms. Now, usually one would argue that Sri Lanka is a dualist country. We are not bound by international law unless we have a law on our own. But here the judgment, I'm happy to note that it dispels that particular argument to a certain extent. And although there's no specific law, it's like, the fact by commenting on the evolution of international law related to children's rights, and then the recognition of same by Sri Lanka and the Sri Lankan government, and then also making certain references to the circulars issued by Sri Lankan ministries is suggesting that we are bound by them. So that is very important, I think, and especially we at certain forums we hear that we are not bound by what the international law says, but I think in relation to children's rights, this particular case, and then also a couple of cases before, there's ample evidence that we recognize children's rights as per international law, in domestic law also, although we may not have specific laws related to corporal punishment. Then also it talks of the General Comment 8, which is like, which has a great lot of detail related to corporal punishment, its impact. Then it talks of the definition of corporal punishment in it, and states any punishment in which physical force is used and intended to cause some degree of pain or discomfort, however light. Most involve hitting, within brackets, smacking, slapping, spanking children with the hand or with a whip, stick, belt, shoe, wooden spoon, etc. But it can also involve, for example, kicking, shaking or throwing children, scratching, pinching, biting, pulling hair, or boxing ears, forcing children to stay in uncomfortable positions, burning, scalding, forced ingestion, for example, washing the mouth with soap or giving hot spices. Like so, this is significant that this like very broad definition is referred to. So basically, also it confirms that corporal punishment invariably is degrading. So which justifies it being considered under section 11. Then also it even talks of like other forms that are not in keeping with the good practices, such as like, for example, punishment which belittles children, humiliates, scapegoats, threatens, scares, ridicules children. So it's a very wide reference that has been made. Then also the judgment dispels the myth that equates corporal punishment to discipline. So now often when we advocate to ban corporal punishment, people knowingly or unknowingly interpret as though we are advocating that children should not be disciplined. That is not the case, and this judgment also specifically states that. So corporal punishment is not equal to disciplining. So no corporal punishment, but disciplining is okay. So disciplining using non-violent methods, the judgment talks of disciplining using non-violent methods. I think already some reference was made to positive disciplining or positive parenting, which like we are also working on. So so this is very important actually, because nobody's telling don't discipline the children. Often when we go to the ministry or to another partner or to a teachers union, sometimes we get this so you're telling don't discipline children. No, that is not what advocates of like anti-corporal punishment advocates are telling. Then it recognizes that Sri Lanka has understood the need to curb the widespread use and acceptance of corporal punishment. This mindset of the state can be derived from the developments in law circulars exhibiting the attitudes of the Minister of Education and from attitudes expressed in judgments related to corporal punishment. So here the judgment is very, very specifically telling, you know, the government position is not to hit children. That is very, I mean, the social norm, the people's belief may be different, but the government policy position is very, very clearly stated, and it's giving these examples. So the government policy position is that there cannot be hitting of children, so as punishment. So that is also a very significant point there. Then another very important thing actually that I noted was the detail that it has given to a certain example in the penal code. So which is of course one of the points that we have also made in different forums. That is in section 341, the example related to criminal force. So in section 341, there's an illustration which states a schoolmaster in the reasonable exercise of his discretion as master flogs B, one of his scholars, sorry, a schoolmaster who flogs his scholar. A does not use criminal force to B because A intends to cause fear and annoyance to B, something to that effect, it's there. Now, so basically telling, like, you know, the giving a right to a schoolmaster to flog children. Now, that's a very bad example, in my belief. So, the judgment actually considers this illustration as archaic. The word used is archaic. Now, so judgment considers the illustration as an archaic approach that has yet not been relieved, that has yet not been repealed. So, which suggests that this has to repeal. So, the careful reading of the words actually is giving the clear message that this has to be repealed. After this judgment, actually, I hope the Minister of Justice will take initiatives to see that this is repealed. This example has to come out. Then also the judgment gives reasons for that. Like, you know, and it goes on to say that Penal Code Amendment Act of 22 of 1995, where the offense of cruelty to children was introduced, and also to the Penal Code, the Act of 16 of 2000, where injuries kind of is expanded to include psychological and mental trauma. So it is actually referring to the judgments and the changes in the law in 1995 and 2006 to show that the example in 341 is archaic. So primarily saying that don't be guided by that particular example. You have newer laws in 1995 and 2006, be guided by them until this particular thing is changed. So that's a message that this judgment is giving. And also it states the judgment implies that the corporal punishment is illegal in Sri Lanka. It specifically that implies that corporal punishment is illegal in Sri Lanka when it states that the criminalization of corporal punishment is drastically different from the approach taken by the principal enaction in 1883. Now, this particular line has to be read very carefully. The honorable judges are telling, all in agreement, the criminalization of corporal punishment, that is currently it is criminalized, it is telling. The criminalization of corporal punishment is drastically different from the approach taken by the principal enaction, that is the principal enactment of the Penal Code in 1883. So there's a very strong point there. For advocates, it is criminal, it is illegal. Basically, it is illegal. Now, also, like, you know, then do we need another law? That's another question. We will come to that. Then there's a lot, I think I have only 6 minutes more. There's a lot on the circular 2016-12, but unfortunately, people don't know about this circular. Now, it is possible that the people came to know about the circular only after this problem, because I can remember such an incident related to the school, and where I was actually interacting with the relevant people, and they were referring to the 2005 circular, and then I had to tell no, this is actually a group of principals, and I had to tell that no, there is a 2016 circular. So the message is I think for the Minister of Education and partners of child protection to actually educate until the law is changed, until there's another law comes, to educate teachers of this particular circular in detail, because it's a reasonably good circular. It talks of positive disciplining also, and it's quite good actually. Then also the judgment, nogahana lamekui and handinogana hoddakui. In Sri Lanka, we have this, a child who is not beaten is like a curry which has not been stirred. Now the judge is critical of that. He is putting all that into archaic views. And he says that he argues that this view does not essentially originate from Sri Lankan culture, and that these attitudes have crept into our society through the colonization. It makes reference to such recognition in English common law, and also there's reference to French law, where that's all right, where it was all right to beat a child, all right to beat a wife, all right to beat slaves, all right to beat servants. So now we have long past that time. Are we willing to accept somebody beating the wife for being naughty? Then how can we accept this? Right. Then also there's reference to Chulavansa, I briefly mentioned before also. Chulavansa, where it says that during the Anuradhapura and Polonnaruwa era, where great kings of Sri Lanka were ruling the country, there was legislature explicitly stating that there should be no physical punishment for both children and adults. So, so I think it's very, very clear what this judgment is telling, and for some of the last few pages of the judgment I have not really elaborated, but it's telling the same thing, where corporal punishment is a no-no. It is absolutely not acceptable. Can we go to the next slide, please?
I'll just say you've got 3 minutes left.
Right, okay. So basically the decision of the court was, the court found that it was a violation of fundamental rights enshrined in the Constitution. Then compensation was awarded, 150,000 to the child by the teacher, and then 500,000 to the child by the state. So that was the decision of the court. Then next slide, please. So on the way forward, I think maybe during the time that we have later also, I think basically to me, I think the way forward, the first thing is of course the need for a law related to corporal punishment. Although these judgments suggest that it is criminal, often at the lower levels, for the police, for example, and at the magistrate courts level, they will look for mens rea, or the intention. So without intention, they will be very reluctant to file a case. So whereas for human rights violations, there is no need for intention. If you have violated the human rights, you have violated, whether you violated it for the benefit of somebody, you can't make such an argument. A violation is a violation. So child rights violations are like that. There is no need for intention. Hitting for whatever reason, for whatever good intention, is wrong. The scientific knowledge is there, so it has to be banned. And therefore, we are advocating for a special law, or not that it has to be a law, it can be a line in the penal code or whatever, stating that corporal punishment is wrong, and that is like, the police can entertain complaints. Then also we are not advocating for punishment actually to the teacher at this current stage, because it's such a norm where 80% of people think that it's all right to hit. We are basically like, advocating that the perpetrator be taught that it's wrong, counseled, etc., so that that it does not happen again. Now, of course, when it's very, very severe, automatically it will be covered under cruelty to children, and the perpetrator will be imprisoned, or like, whatever will happen. But for slight, not without injuries, like, the time may be too early to talk of punishment like that. But correction should be the approach, is my belief. Anyway, I have come to the end of my time, and thanks a lot for listening. And if there are any questions, comments, please put in the chat box. And also, if you noted any errors that I've made, please, especially because I learned that some senior lawyers are also there, please let me know. Thank you. Over.
Thank you, Hemamal. A very rich presentation, and there are many, many questions in the chat. So without further ado, because I think we want to have enough time for the discussion, let me hand over to Dr. Tush, who is the chairperson of the Stop Cruelty to Children, Stop Child Cruelty campaign in Sri Lanka. Over to you.
Thank you, Miranda. Aiboan, and good morning to all. I'm Tush Wickramanayake. I'm a physician, mother of two, and I'm the chairperson of Stop Child Cruelty Trust. My deepest appreciation to UNICEF for giving me this honor to represent all CSOs and NGOs and providing a platform where we can discuss the national child protection crisis in Sri Lanka openly and frankly. It has been quite revealing to listen to the previous speakers, and thank you, Hemamal, for the exhaustive explanation of the legal proceedings and the Supreme Court judgment, which I will not touch anymore. But it's imperative that we appreciate that despite the work that has gone on for 30 years, government after government, authority after authority, that we cannot be proud of the situation that we are in at the moment. We simply cannot. 30 years after we signed the UNCRC, we were issued with a red alert in 2018 by the Committee of the Rights of the Child on 5 categories considered as being critical and urgent to be addressed. One of them, number 1, priority was ending corporal punishment in Sri Lanka. Furthermore, the statistics, Ncpa statistics shows that cruelty to children, cases of physical punishment have increased, trebled from 2010 to 2019. And our very own minister, Professor G.L. Peris, confirmed in Parliament in October 2020 that Sri Lanka during the first half of 2020 had the most astounding number of cases reported to Ncpa, and that he was unhappy with the speed in which they were resolved. So we have issues, people. We really do have to admit that government commitment cannot be restricted to just paper or policies. So let's make this session not just about tapping ourselves on the back, but also being frank so that we can find some simple solutions, doable solutions during this forum. And perhaps I would like to earnestly request UNICEF to have another session, timely session, so that we could monitor the progress and that we are all committed to it and we are held accountable to what we discuss later on. And on that basis, I would really like to ask Miranda also, I have 15 minutes to please allow me at least another 3 or 5 minutes more, because at the end of my session, I'm going to tell the viewers here how the international community achieved it and why can't we? So it's important that I get that few minutes, please. So starting off, I actually came prepared today, having spoken to so many other CSOs and citizens who are concerned equally as me. I am also a survivor of violence, just like Miranda, as a child as well as an adult. And most advocates come in to the forefront because of the adversity that they experienced in their lives. And I came in because of my own daughter having experienced corporal punishment and mental abuse in an international school here. So, you know, it's the passion that drives us. And one of the things, so I have 5 things to try and bring out today to the table with some solutions. And the very first thing and the most common thing that has been repeated by every CSO and every citizen is the strained relationships that we have with the government authorities. Unfortunately, even though the government says, let's work together, and I applaud Preetika, who said, let's work together. Yes, it's wonderful that we say, let's work together, but we often find that even though heads are nodded and agreements are made at a table, that we don't get a response to a complaint that we make. We don't get a response to a letter that we make. We don't get to see the relevant ministers or the authorities afterwards. There is no follow-up. And then, you know, there's also a huge kind of derogatory feeling towards CSOs and NGOs with this, you know, very bad feeling that we are NGOs, we are non-governmental organizations, that we are working for a foreign agenda, for foreign money. But nothing is further than the truth, because we are all advocating and working, and we want to work together so that this is for our children, for the children that experience issues in our country. On the 7th of April, on World Health Day, WHO reiterated that there is such a discrepancy of providing help to the nations across the world, and that it was unfair, yet it is preventable. Health of a nation is not just prevention of disease. Health of a nation is to ensure that people are physically, mentally, spiritually, and socially healthy. And when corporal punishment happens to a child, all of those systems are broken. All of those chains are broken. And it is imperative that we take the advice of international organizations such as WHO as the preventive mechanism. Number 1, they recommended on the 7th of April was that governments should work closely with the people, with civil societies and NGOs. And any credible civil society NGOs' responsibility is to work as a bridge from the people to the government. It is our responsibility to take the problems to the government, discuss, find solutions long-term, and deliver it to the people. Sometimes we have criticisms, but that does not mean that those relations should be strained, because, you know, leadership is all about humility and accepting those criticisms so that we can work together. So I would like to request earnestly from Preetika that Ncpa actually takes us on board to the discussion tables as agreed, and give us the opportunity to be stakeholders for our children. Number 2 is the implementation. We all know that there are wonderful policies of years long, you know, and it's no good leaving them in paper, stuck in some file, or be able to come out at forums like this and say, yes, we've got X, Y, Z, but if it's not being implemented. So there are 3 things that need to be implemented to end corporal punishment in this country. We heard over and over again about this circular. By the way, this circular is not available anywhere else, not even on any government, not even on the Ministry of Education website, but please go on to www.stopchildcruelty.com on the resources page, and you will find everything you require, including the 2016 circular. So the circular is there. Then there was an Ncpa study done in 2017. That too is available on our website. giving 18 recommendations, and the main stakeholder of that was the Ncpa. It was done by Ncpa, and those recommendations should have been enacted by the Ncpa, but we can't see any palpable changes that have happened because as a result of that. So those are things that really need to be done. And in terms of the circular, it has been requested of me to please mention that the circular is only valid for government schools and government approved private schools. We have a private schools department, a private separate department in the Ministry of Education, but the Pirivens, the special faith schools, or the international schools do not come under the regulations of the Ministry of Education. So our children, if they have an issue in school, the Ministry of Education does not look after our children. The circular is not valid to our children, so that these education institutions can get away with nothing short of murder towards our children. And also our rights of these children. As citizens who go to private institutions, we are not covered. Our children are not covered by our Human Rights Commission as rights holders. So that is a tragedy. That is something that our government has done in the implementation of the Education Act so many years ago, falsely implemented it without realizing that there will be an era where international education will be part and parcel of the mainstream education in our country. So it's really important that the Ministry of Education extends this circular to all education institutions. If they can implement the Suraksha security plan for all children. It's a private thing, but it is promoted by the government. If they can do that for all students, including the students of the international schools, I do not see why the circular cannot be extended to our children too. Number 3, the attitudinal changes that are required. Now that has been reinforced by the Supreme Court judgment, where they have reiterated, as Dr. Hemamal said, about our archaic myths and things that we accept in society as, oh, we were hit and we are doing fine attitude, and the Kirihoda story, which I will come later on. And to change those attitudes, they must come from grassroots levels. It's no point in us waiting till a teacher is appointed, till a teacher has done something wrong in order to tell them, hello, there is a circular here, you can't hit, you will be taken to court, or, let's get you let's do a training program and do some project. Child protection, for that matter, any humanitarian advancement is not a project. It needs to be a sustained policy-backed program, that a sustainable program. So the training must come even before a teacher is given the appointment. And we, the Stop Child Cruelty Trust, has done training for almost about 800 teachers now. The first we did with Vidyapita in Maharagama in 2019. And it was quite disheartening, quite shocking, in fact, to know that they did not know much about child development, the crucial stages of child development in the preschool age group. They did not know about the positive child discipline mechanisms that Pritika explained. They did not know. So if anyone is interested, please go back to our website, and there is a booklet on happier and safer education, very well illustrated, common childhood misbehaviors that we found in the 2017 Ncpa study, and methods that we have introduced, international recognized methods. So if any one of you wants that, you can download it, and please share it amongst anyone you think feel free to do that. So it's important that the authorities do the training at grassroots levels from the Vidyapitas, ensure that they have some form of child psychology training, to ensure that this training is updated every 2 years, as they do in the international, in overseas. No teacher, no person who comes in contact with a child can be released of this responsibility of upgrading on child psychology training. And it's important also that we have been pressing with larger INGOs. We have been pressing with the Ministry of Education with our module. You know, ours is not quite a module that we have been doing the training with. It's a sessionary program, but we are following the guidelines of SAVE and World Vision, etc. So it's important if the INGOs can come forward and help us to formulate a module and work with us with the Ministry of Education, where this module is compulsory for all teachers to undergo. We are happy to give our resources, our expertise free of charge. So please take that on board, UNICEF, if you can. Lastly, the law reforms. So my fourth point here is about the law reforms, which the Supreme Court has explained and has confirmed. And before going to the Supreme Court judgment, there are so many things that we can do on ground level, which are very simple things to expedite matters. We don't need to wait for court decisions, which comes only once a year. You know, we have a conviction of a child of corporal punishment, maybe once a year. If ever there is a less significant injury incident where there is no physical injury, even if you go to court, and these are heard, you know, on average 10 years down the line, even if you go to court, they get suspended jail term, and you know, you're out free. Nobody ever gets any kind of rehabilitation. They don't get any training. The teachers get punishment transfers, which is quite derogatory, because it makes matters worse, because they are full of anger and animosity that they tend to abuse even more. So this isn't working. You know, so if we keep on saying that we have this policy, we have done this, we have you know, child protection committees, it cannot be that whatever the system that we are working is working fine. It's because we can't see any improvement when the government authority says that our children are sexually abused every 2 hours. We can't be doing this right when the international global agency says that Sri Lanka is in the abysmal 10% of countries least safe against violence on our children. So we need to change tactics. We need to understand where we went wrong and find solutions, rather than glorifying something that we are advocating on paper. So simple things that I could recommend, therefore, is that I would earnestly request that Ncpa work more closely with the Attorney General's department. Please identify the people that you need to know in the CH section, the children's section, which handles all the cases on behalf of the Ncpa. Know who is actually heading it, know the solicitors over there, and have the communication going, because we all know that almost 30,000 cases are backlogged of child abuse in the Attorney General's department. And the cases that are now being heard are only the ones that have come up in 2007 to 18. And I believe they're now coming up to 2012. We are now in 2021. Ncpa, the foremost and the most authoritative body in our country with the most power, more than the ordinary police, more than any other authority, more than a secretary to a ministry. You have the power, use it. And make sure that you have that connection going with Attorney General's department. Insist that these cases are brought forward. And by insisting, you can also take on the responsibility and accountability by having case workers for the cases that you send your Ncpa officers to court. Please do not send officers who do not know about the case, because all it does is that it postpones the case. There are officers who come from the Ncpa representing a case. They have absolutely no idea. They nod their head and say, "Mama danne, I don't actually know about it. I will make inquiries." So then the judge says, "Okay, we'll meet again in 3 months' time." That's not how expediting cases should be. That's not what accountability should be. So these are simple measures that an authority such as yourselves can do in order to expedite and give us relief. These children are adults, that has been mentioned already. And they are in an open fire, burning away from day to day. Their families are burning away. The so-called abusers are burning away. So we need to find solutions. We cannot glorify what has gone wrong. And finally, and this is where I would need a tiny bit of time, Miranda, please, because I did a lot of international research over the last week, and it is only a couple of days ago that I was able to speak to the Nepalese Nepal group that prohibited corporal punishment. So here goes. So we signed as a country that love our children, our patriarchal, matriarchal country, that we protect our children, which a very rich 2000 odd culture of ours, with a multi-ethnic, multi-religious society that promotes, or supposed to promote, avihinsa, or non-violence. We signed it as a first country in 1991 and ratified it. There were 3 countries remaining to sign the UNCRC. That was Sudan, South USA, and it was South Sudan, USA, and Somalia. And South Sudan and Somalia signed and the UNCRC in 2015 and ratified it, but USA still hasn't ratified it. But countries that signed it after us, countries that took on this mantle, took on the torch to protect children, have now prohibited this in their countries. It's not 100% success, but there is palpable changes and success rates. So let me come to that. Sudan, who signed it in 2015, actually implemented prohibition in 2011. And this is a country that was strive with violence. And they have found that the violence has decreased. South Africa, which was rich of apartheid, racism, color issues, this country changed it, prohibited in 2018, and so did Nepal, I think 2015, sorry. And Nepal, our nearest neighbor, did it in 2018, and Scotland did it in 2020, although Korea has now beaten everyone else again as the latest country. Now, in all these countries.
2 minutes, Dr. Tusha, so we can have time for the rich discussion.
Absolutely. So all these countries that are prohibited have shown that the youth violence and violence in society has decreased. And how did they do that? Number one is that they had constitutional changes. They brought in a separate section. When I spoke to Nepal, they had a separate section for children in the constitution. And they made a rule that the Children's Act must be implemented in 3 years, not 5. 2, coalition of CSO. So if anybody is listening, please get in touch with us on info@stopchildcruelty.com if you want to work together with us from today onwards on our major campaign, which one of the questions has come, and I'm glad that they brought that up. It has to be a major public campaign. So join us on the Handi Noga Hadana Hudda Spare the Rod campaign, which we will kick off as of today. And there's another question. The 4th way that they did, the heralding of the prohibition of corporal punishment was done in many African nations by banning the sale and production of canes. There's a question that has come up. So we will be starting to endorse that as with the campaign today. And child protection, lastly, is not dependent on any single individual, any single organization, or any single government institution. It is a collective social responsibility. And I warmly welcome you to join Stop Child Cruelty or any other organization that you feel is credible and is able for you to work with and support to ban corporal punishment in our lifetime. Thank you.
Thank you, Dr. Tush. Some very powerful points made there. There are many questions in the chat, and I'm sure that there are other questions that people are burning to ask. So Himaja, over to you to facilitate the question and answer session. Good luck with that. Imogen, are you there?
So moving on to the Q&A discussion, can I please ask the panelists to answer any questions that may have appeared in the Q&A box? And also anyone who has any questions, you can type it into the Q&A box. There are a few questions that I will read out and direct to the panelists. The first question is for Ms. Preetika. Does the Ncpa monitor the practice of corporate punishment in a school setting, and what is the Ncpa's monitoring mechanism?
Hello, can you hear me?
Can hear you, Ms. Preetika.
Yeah. On receipt of complaints, yes, the inquiry is in twofold. Departmental inquiry will be referring it to the Ministry of Education, the provincial level, or the Isrupaya for the national schools, and Pirivenas and other educational settings, and the criminal investigation by the relevant police station or the nearest police station will be monitoring the implementing of the law. That is what the monitoring that we do at the moment. The investigation is in twofold. One is the criminal and the other one is the departmental. And we monitor. But those are limited to the complaints that we receive. Over.
Okay. There is another question for you, Ms. Preetika. Proponents of corporal punishment after the judgment, particularly teachers who felt victimized, what is in place in terms of an impactful public communications campaign by the Ncpa in the near future addressing corporal punishment?
The question is not all that clear, Himaja, what is meant by the writer. I tried reading it and finding an answer before you read this out, but it's a little bit difficult what his thoughts are, what he's really aiming at.
I think they're asking the public in terms of the next steps, in terms of informing the public on corporal punishment, if there's anything.
Not clear. I'm sorry. In terms of the judgment?
I believe in terms of, or maybe
in terms of the judgment.
May I have a go at that, Himaja? Okay. I think what the writer asking there is, what is a public campaign that Ncpa has on behalf of the government and the state authorities to encourage people not to hit our children? That's the question. So most of the things that the government authorities are doing are with key stakeholders. You know, it's not just with the public openly. So you may be doing training with teachers or training with, you know, parents, but there is no public forum. There is no campaign going on TV. There are no advertisements going. There's nothing coming in the media. There's nothing coming in the newspapers, that sort of thing. So I would like to
quite right. We are not going via media. We do things that you will not be able to see these activities or camp or what we do. It's a silent approach. We will not be giving publicity, but we are committed. We are doing it merely because it's not reported in media, not reported in social media, not reported in TV. That does not mean that government is silent, that government is not doing anything.
Yes,
we are.
You're right. You're right, Preetika. I think you're right. But what they're asking is for the public thing. So may I help out? If you could please Rehan, if you could please put the article that I wanted to show off. I was kind of rushing
Was it
across.
you who asked the question? Was it you who posted the question?
No, it was somebody else, but I can help
So if you
with this.
would like to
it
know
was
that
not me.
person I meant by putting that question.
Yeah, so
Isn't
maybe
it
I can
better?
also help out with the public
All right.
support. Maybe I can help
I
out
think it's
also.
for all of us, yeah, as
Yes,
well.
yeah.
So if you could
we've
put,
definitely
so,
been
for
putting this
everybody's
out
notice. Sorry.
through our
So-
networks as well, and clearly having this public facing webinar today on the International Day to End Corporal Punishment, and have supported an informal translation into Sinhala and Tamil. So I think that there are many things that have been done since the landmark verdict came out in terms of communication. So it's for everybody, I think, as well, to communicate. Please go ahead, Tush.
You're on mute, Tush.
Thank you, Miranda, for the reassurance. And I also wanted to say, because, we get asked the same question, what are you actually doing? So there is a leaflet that we have designed, which we have handed over to the Ministry of Education to be handed out to all the school entrants as of this year, about happy and safer education, focusing on the myths of what we say in general terms. And actually at the bottom there, if you go to our website, it's there. If you go to the bottom, it actually says about the circular. So, encouraging parents not to request the teachers to hit and teach their children. So this is in support of the teachers as well, so that they can actually uphold the circular. So this is one of the public campaigns that we are hoping to kick off as of today. If anyone's interested, you can download it also.
Thanks. Himaj, are there some other questions in the
Yes.
chat?
There is a question in relation to positive disciplining. So is UNICEF, Ncpa, or any other agency aware of restorative practices for schools? Are there any steps to introduce this model, which is better than positive disciplining? And has there been any work done with this regard? To anyone who can answer.
Yeah, I think Preetika can also tell. The NCP has come out with a booklet on positive disciplining, which I have seen basically as a, maybe pre-printing, I saw it, but maybe that's out.
It's available in the website, Dr. Hemamal. It's available in our website in all 3 languages.
Okay,
it can be downloaded, and we've started talking to teachers and distributing it amongst the teacher community in Sri Lanka, so that they can use this book when it comes to issues that they face. And I know that you too have developed a book on positive disciplining with the help of Sri Lanka Foundation Institute. So we are using both the material,
Right,
Dr. Hemamal,
right,
on,
thank you.
on developing skills. Thank you.
Yes. Yeah, UNICEF is also developing. We are actually reviewing that particular book that was developed with a resource person from the Foundation Institute. We are now reviewing it and improving it. Then also I saw the Ncpa publication, which was very good, which is actually flowing from the research, I think.
Yes, quite right.
Came out in 2017. It is focusing on the particular the situations where children are punished, and then trying to negate those situations. So those are 2 things that are going on. UNICEF's work will be available once it's hopefully before the end of the year, maybe mid or August-ish, kind of available as a web publication, and then maybe later as a print publication. Over.
That question is also directed to SCC. So if I could just have 1 minute to say that, yes, we are doing a series of webinars on restorative justice as part of the Handinoga Hadana campaign that we are going to kick off today. So the details will be available on our Facebook and on our website. So please do join us if anyone is interested.
I believe most of the other questions have been answered in the Q&A box. And it is now 11:50. Miranda, should I call this the end of the Q&A session?
Yeah, I think some of I mean, one question that I answered, like, you know, by typing the box was related to this, the selling of bamboo sticks, canes. So actually, like, you know, we in fact, like, you know, at different discussions, we have told, like, you know, try to ban the selling of bamboo canes, but it was not taken because it was apparently used for so many other purposes. And then we spoke of, like, you know, it not being displayed publicly, and especially near schools and also that kind of thing, because it's used to, like, you know, drive cattle, etc. was the argument that was given. Then also I can recall in one of those campaigns, I think when the president of Sri Lanka was also there at that time, she burned like hundreds of canes, and I think that kind of gave a message to people, and I think children and all the people who were walking around Independence Avenue came and burned these canes. So I think it's a more campaign rather than a legal banning of canes, I think. Then also another thing that I thought I could tell, I watched one of these soap operas kind of things called Sindhu. And in one of the episodes, I heard something nice, in the sense, like, you know, it generally promotes corporal punishment, hitting. And then in this particular episode, the teacher told, usually we say, stir the pot and stir the pot and something. She used it in a different manner. Hit the gravy, and she used that in a different way, so that to show the absurdity of that particular statement. So I think a lot of work through campaigns, through maybe getting our versions included into soap operas, like, you know, people who are listening can contribute actually to do that, because like, you know, it's a huge effort we all will have to make to end this menace. Over.
If I could add, actually, when we had a meeting, if you remember, Hemamal with Ncpa, with UNICEF, we had a proposal that we took to the government about banning canes. And although the government wasn't very partial to that proposal, we now find that some of the African countries, including Nepal, including Sudan, one of the things that they first did was ban the sale of the cane. And I also want to say about this handi noga hadana hoddai noga hadana daruai, actually it's a misnomer. The correct wordings are, or the correct vyavahare tibune dawasala handi noga hadana hoddai nobala hadana daruai. So the child who doesn't get attention will fall into trouble, and that's the correct use of that.
Thank you. I see one hand up. There's Dilipa Manawadu with a hand up. Would you like to ask a question? Now the hand has gone down. Oh, Dilipa, please, if you want to ask the question, please do unmute yourself and ask to the panelists.
Yes. Thank you. Can you hear me? Yes, I can hear you. Hello, can you hear me?
Yes, Dilipa.
Hear you.
Right. Okay. Thank you so much. I just wanted to clarify my question, because I think both my questions were misunderstood. So the second one was misunderstood more than the first. So I'll go with the first one. I was referring to whether there was any thing done around introducing restorative practices to schools. I heard a lot about positive discipline, but that's not the same as restorative practice. restorative practice is more like a culture change. It's a climate change initiative for schools, which I believe is a lot more impactful in the long run. So that's the question I asked, not about positive discipline, about restorative practices, whether anything has been done up to now. So I think Tush answered that question from her point of view, but I think UNICEF and Ncpa sort of got the question wrong. And the first one was, I was referring to public communications campaign simply because there are plenty of parents and teachers who completely believe that corporal punishment should still exist. We all know that, that's why we're here discussing it. So when I referred to public communications, I'm urging Ncpa that you should do something about it, and it's nothing to hide. We need to get out. You don't have to be doing things in secret. I mean, I heard something like that being said by Preetika. It has to come out. You have to address it to the public. So there's more awareness of the public, of more awareness of the parents about children's rights, as well as their own parenting styles. We need to support the public to do the right thing. That's the question that I asked.
We are not
first.
hiding. Thank you for posing that question. We are not hiding anything. It's just that we are not moving for media publicity. We work with children, we work with parents, we work with public, but it's just that we are not getting cameras and media to cover the events. We work with children. Simply that. Thank you for your suggestions on restorative practice. Your comments are being taken note of. Thank you so much, ma'am. Thank you.
Hemamal, do you want to say something on restorative practice?
I actually did not understand what was meant by restorative practices. I mean, we related to children in conflict with the law. Of course, we are talking of restorative practices. So basically, I mean, in the schools level, this is basically being naughty, sitting on a wall kind of thing. I'm not sure how the restorative approach is applicable. Yeah, anyway, what I wanted to tell was actually basically related to this, the Ncpa can do certain things. All of us can do as individuals also. We can write to the newspapers related to the, for example, about the justice and what people can do and make noise about it. Then we may know certain we'll say, because we are developing our strategy right now. Once our strategy is fully developed, we will have all those. But in the meantime, we'll say the teledrama producers, the film producers, the musicians, getting them to sing songs related to the abuse and then how painful it has been for children. So we can brainstorm and think of the different things that we can all do, because it's a huge task, because changing the norm that is which has been there for some time for 80% of the population is a really uphill battle. The law is not going to change. So a lot of things have to be done. And as much Ncpa is silently doing a lot of work, like Tush is doing a lot of work, we are doing a lot of work, and everybody, I think we have to join hands and then see that this is this is there, and this is not put under the carpet, and we act on to see that our children are not punished. It's our duty for all the children in Sri Lanka. Over.
Thanks, Hemamal. We're now running out of time on this webinar. I can see that there's a lot of discussion more to be had. It often happens this way in these webinars. I would like to see Madam Preetika from Ncpa, if you have some closing remarks before I make mine. You're on mute, Madam Preetika.
Thank you for this opportunity. We were able to gather more ideas and thoughts and concerns from the panelists as well as from the participants. It's always a consultative process, so your ideas are valuable. We value it. And I'm happy we would be able to work together in the future on protecting children, not only from corporal punishment, from all forms of violence, all forms of abuse. As government, we seek your support. We seek a collaborative approach, integrated approach. Thank you.
Thank you, Madam Pritika, and thank you to all the panelists. I mean, I think it's difficult to sum things up. There was many things said today, but I think, you know, a critical thing is this change in the law. And I was very encouraged to hear that there is a committee who's looking into the changes that need to be made. There are clearly sections in the penal code and this CYPO that need to be repealed. And also, as Dr. Tush was saying, this circular from 2016 really needs to be for all schools and for all children in Sri Lanka, no matter which type of school they go to. But you know, a public-facing thing would be to change the law and to make sure it is prohibited at school, at home, and institutions. Then, you know, and as many countries have experienced, you know, I gave the example of Sweden, that was the first country to prohibit corporal punishment in all settings in 1979. But it takes decades and it takes generations to really change the mindset and change the norms and practices that sit behind corporal punishment. Clearly, there's something to do with business and selling canes. It seems like things have been done, but that needs to be something to be revived, perhaps. And there's a question about data. I've heard a number of times since I've been in Sri Lanka, you know, cases are going up, cases being, I would say cases that are reported are going up. And in some circumstances, we in the child protection field would say that this is a good thing, because what we want to see is more cases being reported to the services. What we don't have yet in Sri Lanka is national prevalence data, because there's been no studies at national level to look at discipline practices or violence against children, as there have been in other countries. The study of the Ncpa in schools is really useful and gives us great data, but it's still not yet national prevalence data. And we would need that to be able to see where are we in terms of prevalence in Sri Lanka. So something that I think as well to do on data. And finally, I think, you know, going back to my example that I gave at the beginning, I mean, I really feel very strongly about this attitudinal change and movements over time. I think parents right now, particularly in Sri Lanka, with the schools closing again, are going to struggle. Everyone's back on online schooling. And this is the moment when I think, you know, more needs to be done to provide positive examples and practical tools about how to manage children. Parents are under stress. They've got to try and also manage their stress and educating their children. I've seen a lot of chat on social media, and I know that parents are unfortunately, you know, resorting to physical measures, but you've really got to believe that it's possible. And I think having those practical examples and this firm belief that hitting children is not going to help them learn, hitting children is wrong, and that then needs to come in our everyday practice as parents, as teachers, and as, you know, examples in society. Thank you so much to everybody for participating today. I think it's been a really interesting debate. Thank you so much to our panelists, and I look forward to continuing the debate and continuing to take practical actions to end corporal punishment for children in Sri Lanka. Thank you.